Good morning. May it please the court. Chief Justice, Justices of the Supreme Court. My name is Mr. Hanson and Carlos Ramon Mulatillo. My name is Steve Gardner. I'm an attorney from Ottumwa, Iowa, and I represent Mr. Mulatillo. A quick reading of the briefs in this case reveals that the primary issue is the district court order disqualifying Mr. Mulatillo's counsel of choice for his trial. Well, I guess at that point it was scheduled for another 6 months down the road by that point because the court had already continued the trial. The counsel that was disqualified was me by the Wappo County District Court, making a finding that I had a serious possibility of a conflict of interest because I represented a defendant in a criminal case in September of 2014 for a period of 1 month, who subsequent to my representation became a confidential informant working for the Drug Task Force in Southeast Iowa. And after my representation of that individual for that 1 month, he is alleged to have been involved in the sale of illegal narcotics to my client, Mr. Mulatillo.
Kind of where I pinpoint the case, Mr. Gardner, and tell me if I'm wrong. I understand you deny this, but the state contended below that during the time period where you represented this individual who subsequently made some deal to work off his charges and allegedly sold the illegal drugs to your current client. After that, during that time period when you were representing this state's witness, this informant, they say that you were actually involved in discussions with the prosecution about working out some kind of a deal of this nature. And you deny that, right?
That is correct. I do deny that.
Now, will you agree with me that if in fact, I understand you deny that, but if in fact you were involved in doing that, that probably would be an actual conflict that could well affect your ability to cross-examine this individual at trial and would present an actual conflict. Would you agree with that?
Yes, I would. And I would also respond that the state didn't allege that I had those communications. What Ms. Herring, the Drug Task Force prosecutor, alleged was, in fact, what she said to the district court, I don't know what they discussed, but there's a possibility that they discussed the issue of this defendant working as a confidential informant. That's what she said. She didn't say it happened. She said it may have happened. And then they didn't present him, or they didn't present the prosecutor to establish any claim that those communications did occur.
The record indicates that you entered a guilty plea, not guilty plea, I'm sorry. You filed a motion to produce, which looked to me like a standard motion to produce.
It was form.
Yeah, form, and then you withdrew 3 days later before you even got the motion to produce. Did you have any substantive conversations with your client over that time, or was it all more pro forma that you're just getting into the swing of things, as we call it?
My entire communication with that individual, that defendant, that client of mine was 1/2 hour. I believe that it was a non-scheduled appointment, that he walked in off the street. We prepared an attorney fee contract and came to an agreement concerning a retainer fee. He agreed to it. I filed my appearance. I got the trial information, and I prepared a written arraignment. He came into the office and he signed it, and I didn't even meet with him then. I met with this individual once. Wouldn't even recognize him if I saw him on the street.
Did the state, I couldn't find this on the record, did the state present any evidence?
None.
That you had, well, let me finish my question.
I'm sorry. I jumped.
Did the state present any evidence that you had any, that you obtained any confidential information from this informant who was their employee, allegedly, because he was working for him in some way or form, that where Mr. Was it Davidson?
Yes.
Did Mr. Davidson explain to you, did Mr. Davidson tell the state, and they put on evidence, that you had some information he told you that would be, would conflict you out?
No.
Here's the thing, as I looked at this record of the hearing before the district court, you got up and made a professional statement similar to what you're telling us today. That that this was a very limited representation, and et cetera, and would not affect my ability to cross-examine this individual at trial. But the new attorney for that individual came in, and then he made a professional statement, and he said, I was told by the former drug task prosecutor that she did have conversations with you about a potential deal, something like that. And my question is, I mean, what do we do with that? It seems to me that a professional statement avoids lawyers having to take the stand and testify under oath, but that's hearsay. That's a professional statement of hearsay. So what do we do with it?
Well, I argue that it is hearsay, and I argue that it is such that it should be ignored. I actually asked the individual because Mr. Mitchell, the attorney who was representing Mr. Davidson, followed me, the attorney that represented him when he became a confidential informant. At page 95 of the appendix, I was allowed to do a short cross-examination of him. When did you talk to her? I don't know. Did you take any notes? No. How many times did you talk to her? I don't know. Do you have any records whatsoever of your conversations with this individual? No. Then I went back to my office and I called her to find out what her recollections were. But just as if Mr. Mitchell had said in district court, all I can tell you is what she told me on the phone, which is hearsay just like what Mr. Mitchell had to say. But trying to remember where we were going with that question. But
so my question is, I mean, there needs to be some evidence of an actual conflict. Is it enough evidence of an actual conflict that a professional statement by another attorney that he was told by another attorney that you had conversations with this second attorney, the one who's not in the courtroom, that about a potential deal for Mr. Davidson? Is that enough to establish an actual conflict?
I don't believe so. But I certainly would argue it's not enough to go to the extreme step of denying Mr. Mulatillo his constitutional right to counsel of his choosing. The law, as this court has said repeatedly, is removal of counsel of choice is the most extreme remedy and should only be done in the most extreme circumstances. And in addition, the continuity of counsel is just as important as the original choice of counsel. In this case, I represented Carlos for 16 months before they listed this individual as a witness. For the first 16 months, he was not listed as a witness, which of course means they couldn't even allege a conflict. Now, Mr. Mitchell tried to allege a conflict because of it, despite the fact that Mr. Davidson was not listed as a witness at that time. But
One question for you. I think the record, I don't have it in front of me here, but you obviously filed a written arraignment and a plea of not guilty on behalf of Mr. Davidson in his case, correct?
Right.
And this is where I think the record reflects that these are felony drug charges. Can you elucidate for me what those felony drug charges were?
I believe they were 4 to 5 counts, Class B felony delivery of ice methamphetamine.
All right. And so you represent him during September, October of that fall, which is 2014, and then between that time and January of the next month, so roughly 2 or 3 months, this same individual that you filed this pleading for now becomes the confidential informant who is really the pivotal witness against your client now, Mr. Mulatillo right now, correct?
To the best of my knowledge, it would have been in January of 2016. I don't have any knowledge of what his activities were prior to the allegations.
The basis of the charges against your client are delivery of methamphetamine in January of 2015, again, within 3 months of that period of time, and March of 2015. Am I correct in that summary of facts?
You are. I think from January to March.
One of the issues that state raises in their brief is that Mr. Muatillo did not, at this hearing, actually waive any potential conflict. Now, I mean, he was there, and so I assume he supported the position that you were taking. If, hypothetically, if we agreed with your position and reversed and remanded on this point, would your client do you know if your client would be willing to formally waive any potential conflict if we concluded there was no actual conflict in order to continue with you as counsel?
Yes, that would be the first thing. At the time of the hearing, the state attorney recommended a colloquy with Mr. Mulatillo for him to waive on the record any conflict. And instead, the court took up the Watson hearing and disqualified me from the bench, at which point I couldn't present my client to the court to conduct that colloquy. In addition, Judge DeGeest, about 3 weeks earlier, had continued the case because he found that the state had violated Mr. Mulatillo's due process rights by the late filing of the notice of Mr. Davidson being a state witness. And he said it violated his due process rights because I didn't have time to take his deposition. Well, the more prudent process at that point in time would have been to allow me to take that individual's deposition to find out the facts concerning the circumstances of him becoming a confidential informant. And if a conflict appeared at that point, certainly I could move to withdraw at that point, or as in the Smith case, you'll see where there was concurrent representation. The lawyer's partner was representing a state witness, and they actually had a second lawyer come into the criminal case solely to conduct the cross-examination of the current client who was a state witness. Wasn't given either one of those opportunities.
So if your client now has to proceed with new counsel, who pays for all the time that lawyer must spend to get up to the speed where you are now?
Mr. Mulatillo. And you know, this is a little different from some of the other cases in that it's not a public defender type situation. I am privately retained by Mr. Mulatillo, and a new lawyer would have to be paid by Mr. Mulatillo to get back to where we were 2 weeks before trial in October of 2016.
Do we need to worry that this case may take some more twists and turns with an end result that he gets a second trial because of some ultimate conflict finding if you keep the case?
Yes, very good question, very interesting. If I am disqualified and it is later determined that that was improper, My client's, if convicted, his conviction is reversed, period. No prejudice, no harmless error standard. But if I represent Mr. Mulatillo and the court later determines that there was a conflict and I shouldn't have been representing him, there is a prejudice requirement. Must be shown that Mr. Mulatillo was in fact prejudiced. I see that my time is up, and I appreciate your time, gentlemen.
Mr. Gardner, thank you as well. Mr. Hanson.
May it please the court, affirm the disqualification decision because the district court did not abuse its discretion in finding a conflict. And that's because Mr. Gardner personally represented an important state's witness in a substantially related
Is
case.
this an abuse of discretion when we're talking about a defendant's constitutional right to the attorney of their choice? I mean, why would it be an abuse of standard when we're dealing with a constitutional issue here?
It's abuse of discretion because that's what this court has said in McKinley and in Smith. So, and it's the United States Supreme Court says it's an abuse of discretion in Wheat, that there is that inherent discretion that the district court holds to override. In Wheat, it was a defendant's waiver of a conflict, but it's
an abuse of discretion to violate a constitutional right. But aside from that, let's dive into the facts here. First, we got, I think, a concession, and a necessary one probably, that had counsel had discussions and negotiated about this informant working for the state, that would cause some problems. Makes sense because in the defense of the trial, going after the informant is going to be extremely important.
Correct.
And okay, but he denies it. So my first question to you is, assuming we credit him, I know hypothetically, we'll go back to that, but assuming we credit him, what do we have? We do have, I mean, they're related in the sense, the two cases are related in the sense they're drug crimes. But do we have a disqualification scenario if we credit his statement that he did not participate in discussions about being a confidential informant?
if it is unassailable, that fact that he did not have confidential communications about the issue, then I would agree with you that.
All right, so so that gets us to the pip of the issue on disqualification. And he here and below has been, I think, unequivocal that the conversations did not occur. We have Mr. Mitchell making his statement before the court based on what he was told by someone else. I mean, where does that leave us? On the one hand, I mean, there's a balancing test, I think, under our cases. On the one hand, we have an unequivocal statement. This didn't happen. On the other hand, we have hearsay that someone said something about the conversations taking place. We know that there's a fundamental deprivation of a right to counsel if he's disqualified. Help me, I mean, that's where I see the case. Help me through it.
Sure, and I think the problem with that is the only way, there's only two people in that room at that time. It's Mr. Davidson and it's Mr. Gardner. Mr. Gardner has said his version of what happened there. The only way for Mr. Davidson to contest that is to essentially give up his attorney-client privilege and come into court and testify as to exactly what was said during
Well,
that
the
meeting.
state could have had the prosecutor in, so we didn't rely on hearsay through Mr. Mitchell.
But the prosecutor was not entitled to the confidential communications that happened between attorney and client. The prosecutor.
The state prosecutor, if I understood it right, Mr. Mitchell said that he talked to a prosecutor with the drug task force and that
Right.
she told him that Davidson had conversations with Mr. Gardner about being a confidential informant.
And I might have misread that. I read it as Mr. Gardner had conversations with the prosecutor
Okay.
about Davidson
Okay.
becoming
All
a
right. And I
confidential
think,
informant.
actually, I think you're right, and I'm wrong, so thank you. But why wasn't that witness at the hearing?
I don't know. But the point of not having to haul in that former client to testify is we don't want to
I'm
force
looking for the
them to wait.
prosecutor to testify. I'm not looking for the former client. I understand your point there.
But under your hypothetical that, you know, we're supposed to assume that there are no confidential communications, prosecutor doesn't know anything about that. She wasn't in the room during the confidential communications.
It would have been interesting if the prosecutor would have got up and said, look, I had 4 or 5 conversations with Mr. Gardner. And Mr. Gardner told me that his client didn't want to be an informant. But we were working on convincing him otherwise, and then the representation ceased. Now, if the record said that, I'd be quite concerned, frankly, I think. But instead, I'll just characterize it as thinner.
Well, of course it is, and I'm not coming before you today to say this is the strongest case requiring disqualification, but it is a case that the district court had an adequate basis to question whether there's a conflict or a potential conflict that was going to arise in the future. And Rule 32, 1.9, Comment 3 says we're never going to know, or in a lot of cases, we're not going to know the exact communications that were had between attorney and client. And frankly, we don't want to know them because that forces the former client giving up privilege. So we look at what in a normal case would the communications have been. And in this case, the district court finds that there is this connection, apparently credits Mr. Mitchell's professional statement, and finds that Mr. Gardner must have had some sort of communications about becoming a confidential informant, or about Mr. Davidson becoming a confidential informant. And that discussion is normally going to include things
But the
like,
court
why do you
had-
want to become a confidential
But the
informant?
court had to have some substantial evidence, and this kind of hearsay strikes me as not, maybe not substantial evidence. I mean, Mr. Gardner's point is when we get to trial and Mr. Davidson's on the stand, all I'm going to do is ask him things that are in the public record. You were charged with this and this and this and this, and you faced this much time for this and this and this and this. And now you've made a deal with the state to work off that time, and in order to avoid that time, you need to implicate my client. Isn't that right? You know, something like that. And that doesn't require any confidential information, does it? And it's not something that is going to implicate any confidential information, is it?
So I think that form of impeachment, part of it will be public record stuff, like what the charges were, what time you faced. But some of that is also going to be more personalized to the particular confidential informant. Was there a particular reason you wanted to make a deal instead of facing the charges? Was there something?
If he
I
was
mean,
allowed to
perhaps-
take, but if he was allowed to take the deposition, like Mr. Gardner suggested, all that stuff would have been gone through, and the court would have had a better idea or understanding whether Mr. Gardner used information that may have come from his representation or may have been public record. Of course you're going to ask him, why did you become a public informant? What did you get for it, and things like that. But there was a way to discover all that stuff before.
But those are the same questions that an attorney representing the former client making the decision to become a confidential informant would have learned during their private discussions. So the conflict arises when Mr. Gardner or another attorney is put in the position of exploiting the confidential communications to know what right questions to ask during
Those are the
trial or
questions
deposition.
any competent attorney would ask. Why'd you become a confidential informant? All those questions they would ask, and they would get the answers. Now, if you see Mr. Gardner or some other person in the same circumstance, you know, saying things that indicate that, well, his questions indicate there is something more than just these general questions, but that is a question any competent attorney should ask in a deposition. So I don't know how you get to any confidential information.
But aside from that, inherent also in that decision to approach the prosecution about becoming a confidential informant is the decision that we're no longer on the guilt or innocence question. It's not we're going to fight this at trial. It's we're going to try to get the best deal possible. And that involves presumably an admission of guilt by the former client. And again, that's something that a normal attorney is not necessarily going to be privileged to learn just from the public record.
Here's the other thing that's kind of troubling to me, and I think Justice Waterman alerted to. It's that you have a defendant who's already used up, presumably given a pretty substantial retainer to Mr. Gardner, and now is going to have to start over, and that's something that I think maybe could have been avoided if the state had raised this issue early on. I looked in the record and I noticed that fairly early on, I think it's in February 2016, the prosecutor sends an email to Mr. Gardner and says, well, you used to represent the confidential informant, but doesn't say who the confidential informant is, doesn't say you might need to withdraw, doesn't ask for the Watson hearing, doesn't do anything. Instead, you wait till we're now on the eve of trial, and then at that point in time, after all these resources have been expended, then the issue is suddenly raised. And isn't that a troubling thing for the state to put a criminal defendant in that position?
No, because it's not like it's really starting over at square one. There's the work that Mr. Gardner has done can be picked up by another attorney and take it over, and that happens all the time. It's not he has to redo every deposition. It's not that he has to refile every motion, and I think it is significant.
I mean, I don't know your criminal defense experience, but usually, a lot of times when they come in, you sort of, the lawyer goes to the client, well, how much money do you have? Well, that's the retainer. That's how it works. Or how much money can your family raise? I mean, I'm guessing he probably doesn't have a second pot of money that he can go give to another lawyer, perhaps, right?
Well, there's also no proof that Mr. Gardner has exhausted the retainer, so there could be money left over. But the point is, it's not like the state sprung this on him at the last minute, and I would dispute that the February email is the first time that Mr. Gardner would be on notice. He also got in discovery videotapes of each of these drug transactions, and according to the state's motion, it is quite apparent who the informant is. So that would have tipped off Mr. Gardner at that point to really examine, is this a case I should stay in, and is that a conversation I should have with my client about maybe you don't want to keep me as your attorney until something like this blows up.
All right, well, what about the waiver issue? It does seem that, I mean, in some ways, it seems a little bit of a tempest in a teapot. I mean, Mr. Gardner suggested that his client was fully prepared to go through a colloquy and waive any kind of conflict. I guess, so I have two questions. Number one, if that is true, doesn't the problem go away? And then my second question is, what's the procedural posture now? I mean, he wasn't, it seems to me the district court was kind of abrupt, but you may want to challenge that characterization.
So I would say if there was a waiver, the state's interest would certainly be diminished here because there's not...
Diminished or not present. Wouldn't be moving to disqualify. If you had a nice colloquy and assuming it met all of our requirements, that'd be the end of the disqualification matter.
But cases like Wheat say there is still that inherent discretion of the court to kind of police and make sure there's not a conflict of interest that could affect somebody. And I mean, if the court is still fully satisfied that the rules of professional conduct and the disciplinary process will adequately protect the former client's interests, then that's certainly a possibility. The second part, the state came into that hearing saying we want him to waive, and it just never happened. So I think at this point it's a little late for that to happen. The court did exercise its discretion to go one way, and that exercise of discretion was reasonable.
Abuse of discretion to not allow the colloquy to continue and then consider whether to do
Well,
Qualification.
except it was never Mr. Gardner's primary motive to come in and say, we're going to waive the conflict. Instead, he's fighting about whether there was a conflict. So I think if that was the primary intent of that hearing, it was certainly not expressed. But I want to make a final point. If this case is causing so many questions about whether disqualification was required, it is the polar opposite of both Smith and McKinley, and it's essentially the same attorney involved in a substantially related case, yet if the court is not going to find disqualification was reasonable here, I think we really need to question Watson's further vitality, because we have a lot of prosecutors out there who are worried because of Watson that their convictions will be reversed later on because a potential conflict was not addressed on time. So I would encourage the court to look at Watson and overrule to whatever extent Watson still survives. So that the court asks this court, or the state asks this court affirm. Thank you.
Thank you, Mr. Hanson. Mr. Gardner.
Thank you again. May it please the court. I want to start by just saying this. If disqualification is justified under this record, it means that in every single criminal case in which I am involved, if I represented a state witness at any other time in my career, there are grounds to have me disqualified.
No, I think that's an overstatement of what we've said in all of our cases, which is, in fact, it doesn't. It has to have some type of connection to the previous representation. And I'll tell you where I'm having problems with this is, you know, you would acknowledge you have responsibilities and duties to your former client, Mr. Davidson here.
Certainly.
You have a duties and responsibilities to him. You also now, as part of this action, have duties and responsibilities to Mr. Muatillo here as well. And do you acknowledge that there's this real potential that those interests could be different at the time of a trial, when you're now cross-examining and impeaching your former client? Do you see any potential for a conflict of interest there?
No, I do not. And I say that because of two things. Number one, I know what I know and I know what I don't know. And number two, I know the exact circumstances behind the length of my representation and the communications I had with that individual. So I do not see any potential. But
it's fair to say that the court, obviously, in this case, did see a potential for that.
I think the court implied the potential without the presentation of any evidence. The law is that the burden of proof is on the state to show a serious potential of a conflict of interest, and that burden requires the presentation of evidence, which they didn't do. The court merely said, you represented him, it was a drug case, and because of that, that's a serious...
There's some closer connection than just that. I mean, the connection is apparently the matter that you represented him on has now become the basis for the deal that he did that led him to becoming a CI and then allegedly making transactions with your client,
Yes.
purchases from your client.
Yes, and you brought up that email that the county attorney sent me, so I went to it. It not only said, I also wanted to make sure you were aware that you represented the confidential informant, and I think you're right, it's about February of 2016, utilized for Carlos Baez prior to that individual becoming a confidential informant. So what she told me was, I'm not going to tell you who it is, but you represented a person who was the confidential informant prior to him becoming a confidential informant. Then Mr. Mitchell files his motion shortly before trial.
Well, wouldn't it be prudent to look into what that conflict of interest was at that time? And then how do you respond to the fact that you have videos of all these transactions that would, I don't know, I haven't seen the videos, but I assume it clearly shows that it's your former client who is the confidential informant who did the controlled buys.
That's what the county attorney represented at the time of the hearing. I did watch the majority of the videos. I did not recognize the individual, and you have to remember, I only spent a half hour with the individual, and this could have easily been year and a half later. I do not recall what that individual looks like. I did not recall the individual because of the nature of my, the short nature of my relationship. But Mr. Mitchell filed a motion to disqualify me.
Yeah, I'm not worried about that. I'm worried about, or I guess I'm concerned about the timing of this, when in February of 2016, I think my timing is correct, but of February of 2016, you know, you've been notified that you have a potential conflict of interest with the confidential informant who forms the basis of literally all the charges against your client, 10 out of 13 at least. And you don't do anything then to determine whether or not you have a conflict at that time. Do you have any responsibility to look into what that potential conflict of interest may be? Or do we wait until they have to disclose the confidential informant?
Yes, and I did look into what the conflict would be. I went back to the trial information. It only becomes an issue if, in fact, the individual is going to be called as a witness. I went through the extensive list of the state witnesses, and the individual was not on there. The issue of whether my cross-examination would be adequate was irrelevant at that point, because whoever their confidential informant was not listed as a witness. And he was not listed as a witness until 13 days before trial. I actually sent an email that said, who is this confidential informant so I may request my records? It's in the appendix at page 33. And their response was, can't tell you.
You may sum up.
Thank you. Oh, I am done. In summary, the state didn't present any evidence, and the burden of proof is on the state. And in this situation, I denied a conflict, and the court, without evidence, denied Mr. Mulatillo his right to his counsel of choice. I thank you very much for your time today.
Mr. Gardner, thank you as well, and Mr. Hanson, thank you. The case is now submitted. How are you doing? Right. We'll next hear the arguments in Yanka.